They thought he was just another Hollywood tough guy, a man built for action scenes, not courtrooms. But when Jason Statham stood before the United States Supreme Court, facing off against Justice Amy Coney Barrett herself, something happened that stunned the entire legal world. This wasn't a movie. This wasn't a script. And what unfolded in that chamber left the entire bench silent. Stay with us until the very end to witness the twist no one saw coming, and the final moment that changed how the court sees justice. The marble chamber of the United States Supreme Court stood quiet, colder than usual, not just in temperature, but in tone. Sunlight barely filtered through the tall windows, casting long, thin shadows across the rows of carved wood benches. The docket for the day was crowded with technical federal litigation. Most people present were there for one thing: a dry procedural hearing involving indemnities for displaced veterans. Few had bothered to look twice at the man seated at the petitioner's table. Jason Statham wasn't there to perform. He didn't come with an entourage. No suit tailored to impress, no cameras following his every move. Just a black tie, a leather folder, and a quiet presence that was so unlike the man people thought they knew from the screen. He didn't belong here, not according to most of the room. But the moment he stood, that perception began to tremble. His name wasn't listed as lead counsel, but in a last-minute motion approved days earlier, he was granted permission to speak before the court on behalf of a group of veterans whose cases had been repeatedly delayed, mishandled, and forgotten. Their communities, built on promises of federal support, had slowly been dismantled under obscure regulatory orders. Jason had watched it happen, watched men he'd trained with lose homes, pensions, and dignity. That's why he was here. Not to win, to defend. The justices were mostly still. Some brows raised, others remained impassive. Then came the voice that cut through the stillness like a scalpel, firm, steady, and unmistakable. Justice Amy Coney Barrett leaned forward. Her reputation for precision and control was well known. Her tone rarely shifted, but when it did, the room paid attention. She interrupted Jason's opening argument barely 4 minutes in. There was no hesitation in her voice. She questioned not only his legal interpretation of jurisdictional authority, but, more pointedly, his presence in the courtroom itself. He was, after all, not a scholar, not a constitutional theorist. He was an actor, a fighter, a symbol of physical strength. What did he know of Article 3 standing? The gallery remained still, though tension now hung thick in the air. A few sideways glances passed between junior clerks and law students seated in the back. Reporters from the legal press scribbled hastily into their notepads. Barrett didn't stop there. She raised case precedents, called out inconsistencies in his preliminary outline, and questioned whether he had even read Harrington v. Davis, a cornerstone decision in the realm of federal-state boundary disputes. Some smirked quietly. Others waited for him to fumble. But Jason didn't flinch. He remained still for a long moment, as if absorbing not just the criticism, but the weight of every doubt projected onto him by the courtroom. The silence grew uncomfortable, yet his eyes didn't drop. They scanned the bench, calmly, intently. Because this moment wasn't unfamiliar to him. It didn't take place under gold ceilings in black robes, but he'd seen this before, standing in front of people who had already decided what he was, in barracks, on film sets, even in business meetings. His whole life had been a rehearsal for this. What no one in that courtroom knew, what none of the clerks or justices or journalists had bothered to investigate, was that Jason had quietly earned his law degree over a decade ago, not for show, not for prestige, but for purpose. For moments exactly like this. His legal work had always been quiet. Anonymous amicus briefs, legal advisories to underfunded non-profits, case studies written under pseudonyms. While the world debated his movies, he had been studying the Constitution, not in classrooms, but in real-world failures of the system, And now he was here, not to prove anything to the court, but because no one else would take the case. The courtroom expected a stumble, a misquoted statute, a vague retreat. What followed instead was something no one had seen coming. Jason calmly turned a page in his notes, raised his chin slightly, and locked eyes with Justice Barrett. What he delivered next didn't just follow precedent. It reached back through legal history with surgical accuracy. He cited not just Harrington versus Davis, but its dissent, its concurring opinions, and its footnotes. He referenced a lesser-known Federal Circuit decision that had interpreted Harrington through the lens of veterans' benefits and regulatory jurisdiction, one so obscure that two justices visibly began flipping through their clerk's notes. He didn't raise his voice. He didn't seek approval. He walked through the complexities of federal oversight with a precision that came not from theory, but from pain, from real lives destroyed by red tape, from nights spent trying to understand how the same government that decorated soldiers could later displace them from subsidized housing. The Solicitor General seated across from him shifted uncomfortably. Justice Thomas leaned forward slightly. Justice Sotomayor uncapped her pen. But it was Barrett who remained the focal point. She interrupted again, this time not to discredit but to challenge. A test, perhaps. A final push to see where the cracks might form. Jason met her challenge head-on, quoting language from her own opinions on regulatory limits. Not just quoting them, applying them in a way that even she had not fully explored. Her eyebrows lifted slightly. The smirks from earlier were gone. The atmosphere in the court had changed. What began as a procedural hearing had turned into something else, something no one in that room could have anticipated. A battle of minds, a moment of clarity, a confrontation that was no longer about legal credentials or public image, but about substance. As Jason closed his binder for a brief pause, the room exhaled collectively. No words were spoken, but the shift was undeniable. He wasn't just holding his own. He was reshaping the entire conversation. And then, as if to draw a line between what had just been said and what was coming next, Justice Barrett leaned back and uttered a sentence that would become the headline of the day. But what Jason said in return, what he was about to reveal, would do more than dominate headlines. It would silence the entire chamber. Just as Barrett attempted to regain control of the exchange, her next question was cut short by Jason's citation of a legal opinion she had authored 5 years prior. Not only had she forgotten it, she had never imagined it would be used against her. And yet, there it was, highlighted, annotated, and weaponized, with surgical calm. The silence that followed wasn't ordinary, it was historical. There are moments in any courtroom where language fails, not because there are no words left, but because the room understands that something rare has just occurred, something no one prepared for. That silence filled the Supreme Court as Jason Statham gently slid the highlighted opinion across the podium. It was a 2018 decision, buried in a case most had long since forgotten. A matter of regulatory thresholds and jurisdictional overlap that never made headlines. But Jason had found it. And not only had he found it, he had deconstructed it, rebuilt it, and weaponized it with the same methodical discipline he had used in every other part of his life. He didn't point fingers. He didn't gloat. He simply allowed the words, Barrett's own words, to stand where others might have boasted. The room had no idea how to respond. Justice Barrett's posture shifted almost imperceptibly, not in defeat, but in reassessment. Her pen hovered above her notepad without writing. Her eyes narrowed, not with irritation, but curiosity. It wasn't that Jason had proven her wrong. It was that he had applied her own logic with greater clarity than she had anticipated. He hadn't embarrassed her. He had honored the rigor of the court in a way few outside of it ever could. What followed was no longer a hearing. It was an intellectual reckoning. Jason pressed on. He cited Westmoreland v. United States, an overlooked 10th Circuit case that spoke directly to tailored limitations in federal regulatory authority. He connected it to Montgomery v. Louisiana, pointing out how the court had, buried in footnote 23, acknowledged the reasoning used in Westmoreland as instructive, even if not binding. His voice remained steady, his tone unshaken. The rhythm of his logic became the courtroom's new tempo. The Solicitor General, until now composed, had begun flipping through his binder with increasing urgency. He hadn't anticipated this trajectory. No one had. Then came the unexpected. Justice Sotomayor interjected, not to challenge, but to clarify. She referenced a separate jurisdictional framework proposed in the late stages of the Friedman ruling. Jason turned to it seamlessly, pointing out that Friedman's scope was restricted to interstate commerce and did not apply to federal command of state-level administrative structures. He quoted the majority, "does not extend to matters where federal coordination nullifies state discretion." Then, without looking down, he connected it to the present case. It was surgical. What held the room captive wasn't just the legal acumen, it was the restraint. Jason had nothing to prove personally. There was no vendetta, no showmanship, only an urgent desire to prevent future veterans from being failed by a system they once trusted with their lives. That's what landed most heavily on the gallery. The quiet purpose beneath his words. Not only did he know the law, he understood why it mattered. Justice Kagan, always incisive, raised a technical conflict. Wouldn't your reading of Thomas's McClintock concurrence contradict the standard we affirmed in Dennison? Jason nodded slightly. He had expected that question. He turned a page and laid out the structural limitations within Dennison's framework. He showed how the precedent applied in form, but not in function, given the exceptional federal overreach in the current case. The way he explained it wasn't just clear, it was revelatory. And then it happened. Barrett leaned forward again, but this time there was no coldness in her gaze, only intensity. Her question was not framed as a challenge, but as an invitation. If this court were to accept your framework, how would you propose we articulate its limits to prevent misuse? The question was more than technical. It was symbolic. She wasn't asking an advocate, she was asking a peer. Jason responded by outlining a three-part standard: necessity, proportionality, and constitutional consistency. For each prong, he referenced a precedent. Not one of them was recent. They were decades-old decisions, some buried, some contested, but all relevant. His voice didn't falter once. At that moment, the courtroom ceased to be a place of adversaries. It became a forum of mutual respect. Even the junior clerks, initially indifferent, were now typing with urgency. Reporters looked up from their notebooks. What had started as a procedural hearing had transformed into something none of them could summarize with a single headline. Jason wasn't winning a case. He was redefining it. And while the public might later remember the names, the sound bites, the citations, the justices in that room would remember something different. The presence of a man who never raised his voice, never asked for permission, and yet commanded the floor as if the marble beneath his feet had been carved for this very moment. And perhaps it had, because this wasn't about Jason. It wasn't even about the court. It was about men who had served, bled, and been discarded. It was about restoring trust in institutions that too often forget the ones who built them. It was about justice, not as a concept, but as a responsibility. As Jason prepared to close his argument, a new energy settled in the chamber. The Solicitor General sat rigid in his chair, his rebuttal notes now out of sync with the moment. Justice Thomas adjusted his glasses. Gorsuch leaned back in consideration. But all eyes were still on Barrett. She had been the first to question his presence. And she would be the last to speak. Jason paused, not for effect, not for drama, but for purpose. Because what came next wasn't just another citation. It wasn't even legal theory. It was the memory of a veteran named Walter Hayes, a former infantry medic, evicted from federal housing after bureaucratic changes removed his eligibility. Jason had fought for him, too late. Walter died in a shelter 3 weeks before a judge reversed the eviction. That memory had never left Jason, and now it stood at the center of the highest court in the nation. He didn't tell the story with tears. He didn't have to. He told it with the same clarity he gave every case name, the same weight he gave every constitutional reference. The courtroom didn't blink, not once. And as Jason closed his binder once again, this time to signal the conclusion of his testimony, the Chief Justice glanced at the time. But before he could thank Mr. Statham, Barrett spoke one last time. What she said will never appear in the official transcripts. It wasn't formal, it wasn't expected, it was one sentence, and it changed everything. The sentence wasn't a ruling, nor a challenge, it was a request. One that stunned the gallery and shook the Solicitor General so completely that he dropped the pen from his hand. Because for the first time in recent memory, a sitting justice of the Supreme Court had asked, publicly and without condition, that an advocate return to the podium
and help the court finish writing the law.
The request came without warning, simple in its phrasing but weighty in implication. Justice Barrett had asked Jason Statham to return to the podium, not to defend, not to clarify, but to help the court finish. To craft the language that would guide future generations on the constitutional limits of federal authority. There were gasps, murmurs, subtle shifts in posture. It was the kind of moment that doesn't just challenge protocol, it rewrites it. Jason, who had already prepared to step away, adjusted his stance. There was no celebration in his eyes, no vindication, just a quiet understanding that the moment had evolved into something larger than himself. He opened his binder once more, slower this time, not as an advocate, but as a contributor to the architecture of justice. What followed was not a speech, it was an offering. Jason laid out a proposed framework, a three-pronged standard that balanced federal necessity with state sovereignty. Every element had a precedent, but none leaned on ideology. Instead, he built his structure like an engineer reinforcing a bridge. The language was precise, the logic unbreakable, the tone devoid of ego. Each prong addressed one fear the court had expressed over the years: overreach, ambiguity, and unintended erosion of state protections. He didn't erase those fears. He acknowledged them and built around them. The court listened, not as superiors, but as peers. Justice Gorsuch asked if the framework accounted for overlapping mandates between agencies. Jason replied with a reference to Wisconsin Manufacturing vs. EPA, quoting Gorsuch's own language on sovereignty primacy when regulatory conflict arises. That alone shifted something in the air. A justice hearing his own words repurposed, not to impress him, but to honor his logic. Justice Kagan brought up the risk of judicial over-delegation. Jason anticipated her question with a citation from New York versus United States, identifying the threshold of acceptable regulatory handoff. He clarified how his standard encouraged deference where appropriate, but imposed structure when discretion was exploited. By now, every justice had asked at least one follow-up. Every answer was deliberate, clean, purposeful. But it wasn't just the content that held them, it was the clarity. The confidence without pride, the insight without arrogance. Jason had nothing to gain from this. He wasn't arguing a case for fame or status. He didn't want a headline. He wanted a decision that couldn't be twisted 5 years later into something dangerous. And that's what struck them most. His proposal wasn't just a legal strategy, it was a moral blueprint. At one point, Justice Thomas quietly requested a printed summary of Jason's framework. It would later be confirmed that he requested 2 copies, one for the court's records and one for his own private reference. Law clerks would study that framework, Professors would add it to syllabi. But at that moment, it was just Jason, speaking to a room full of decision-makers who had stopped seeing him as an outsider. He had become one of them. And yet, as powerful as the logic was, it was something else that cemented his place in that room, a memory he shared not through drama, but through calm reflection. Walter Hayes. Jason referenced him again, not by name but by circumstance. A man lost in a system that lacked compassion. A case that wasn't precedential, but was unforgettable. And then, gently, Jason asked the court to remember. Not every constitutional crisis begins with an assault on the law. Sometimes it begins with silence. When courts delay, when bureaucracies hide, when no one listens until it's too late. That was the weight of his closing, not judgment, but remembrance. When the Chief Justice finally spoke, his voice carried none of the usual finality. Instead, it carried reverence. He thanked Jason, not for his eloquence, not even for his service, but for the contribution, for reminding the court why it exists. Jason nodded, gathered his notes, and turned to leave. The silence in the room was deeper than before, not tense, not skeptical, just quiet with the kind of stillness reserved for moments people know they'll never forget. As he walked past the Solicitor General's table, no words were exchanged. But the way the federal counsel looked at him said enough. This case was no longer winnable in conventional terms. The landscape had shifted. And when Jason passed the gallery, where veterans, students, journalists, and a few old friends sat, he gave no smile, no gesture. Only a look that said, "This was for all of you." Outside, the air was brighter, clearer. Reporters surged, cameras activated, but Jason didn't stop. He moved through them like he always had, without the need to explain what had just happened. Because those who mattered had witnessed it, and those who hadn't, they would hear about it soon enough. News coverage exploded within hours, legal blogs headlined with phrases like, "The day the court sat still," and "Jason Statham redefines Supreme Court advocacy." Veteran organizations published statements of gratitude. Law professors on both sides of the political spectrum expressed astonishment. But it was Barrett's silence that said the most. She made no public comment, no press statement, until 2 weeks later. At a judicial ethics conference in New Hampshire during a panel on emerging legal voices, she closed her remarks with a line that would be quoted for years. "The bench constantly reminds us that legal brilliance can emerge from unexpected sources, and that the integrity of this institution depends on our willingness to listen when it does." No name was mentioned, but everyone knew. And when the court released its majority opinion in Veterans of Southfield v. Federal Housing Authority, the language included a 3-part framework for evaluating regulatory encroachment, nearly identical to Jason's proposal. Justice Gorsuch authored the opinion. Justice Barrett wrote a concurring opinion. She quoted Jason's interpretation of Wisconsin manufacturing verbatim. And in the appendix, buried between footnotes and procedural details, appeared a reference to a legal contribution submitted by counsel during oral presentation on behalf of petitioners. No movie had ever made Jason Statham more memorable. No stunt had ever made him more respected. And no script had ever been more real. Because in that courtroom, with nothing but pages and purpose, he didn't play the part of a hero. He simply became one. And maybe that's what justice really looks like. Not applause, not headlines, not victories. Just a quiet man in a quiet room, standing up when nobody else would. In the end, Jason didn't need applause. He didn't need cameras. He walked away quietly, after teaching the highest court in the land something they never expected to learn from a man like him. If this story moved you, if it reminded you that wisdom can come from anywhere and that justice still has a voice, make sure to hit the like button, share this video, and subscribe to the channel. Because here we tell stories that the world tries to overlook. and you deserve to hear every one of them. Until next time, stay grounded and stay watching.